Glad I believe we're live.
Hello, hello everyone. This is the panel on the Singapore Mediation Convention. We have a distinguished panel of experts to talk about it, but perhaps I can give you some background to the convention first. The convention has been many years in development. It's been a very important development from a commercial arbitration perspective, where parties have often settled their disputes by way of mediation, but were not able to enforce those mediated settlements in other jurisdictions. This convention promises that those issues can be ironed out. At this stage, it's in the very young phase of its development. It's been signed by 53 countries and only ratified by 6. It has thus come into force, but with limited impact. What this panel is seeking to do is to look at the background to the convention, to look at some of the key provisions, to look at some of the cultural issues that might be faced by users of the convention, and by those who want to propagate its use throughout the world, and to see how it will work, how this convention will work with other dispute resolution mechanisms, and how it will be integrated into the various legal systems. So there are many issues that have still to be worked out about this convention, and I'm sure that this will be a cause of much academic and practical debate in future. But we are hoping to give some sort of spark to that debate, at least on the African continent, and see where it leads us. If I can introduce our panel members that we have today. As I said, it's a very distinguished panel who've got very in-depth expertise in mediation and alternative dispute resolution. First, Agade Lachi is a practicing attorney. He's a lawyer. He's a SEC certified capital market operator and is engaged in investment advising and commercial law practice. Agade is an ADR expert with what he calls a bias for mediation and arbitration, which is a bias we very welcome. We welcome very much in this panel. As a mediator, he has been engaged in the resolution of a broad range of disputes, such as banking and financial matters, inheritance, testamentary issues, etc. He's got a very broad practice that encompasses a lot of commercial areas. He's on the panel of neutrals of several organizations, and he's also, very importantly, an avid lover of sports and a member of the IBB Golf and Country Club in Abuja. Second, we have Judge Alioch. She will be very well known to many of you. She's a former judge and first vice president of the International Criminal Court and has a very substantial pedigree of international and national awards. She was the second woman on the Court of Appeal in Kenya. She holds a master's degree in international affairs from the Fletcher School of Law and Diplomacy, which also awarded her Distinguished Alumna Award. She's an adjunct professor in the Faculty of Law of the University of the Western Cape and has now focused her attention on mediation and alternative dispute resolution. She's a certified international mediator, a certified advanced mediator, a chartered mediator, and an accredited mediator with CEDR London. She also co-founded Aequitas Mediators and conducts mediation throughout the African continent and beyond. She has also, equally importantly, been appointed as the chair of the Cricket Normalization Committee in Kenya, which will bring a different perspective, hopefully, to this discussion. Third, we have Amani Khalifa. Amani Khalifa is counsel in Freshfield's Global Projects Dispute Practice. She handles large complex construction disputes relating to projects throughout the MENA region. and has been recognized as an expert in arbitration and alternative dispute resolution by numerous publications, including Who's Who Legal. Mani also sits frequently as arbitrator in infrastructure disputes throughout the MENA region. She is an arbitrator on the Basketball Arbitration Tribunal, which is an independent tribunal recognized by FIBA, and she is an anti-corruption hearing officer of the Tennis Integrity Unit. She is the co-chair of ERA Pledge Africa Subcommittee. She has a very broad practice in international arbitration and alternative dispute resolution. Then we have a further guest, someone who wasn't on the initial roster, but who very kindly came in to share his experiences. Dr. Adeyemi Agbelusi is the principal partner in Berea & Associates. He's an arbitrator, accredited mediator, and conciliator and mediation advisor involved in resolving disputes throughout Nigeria and other jurisdictions. He has a huge wealth of experience in alternative dispute resolution and a long roster of matters specializing in this very field. He is also a certified management and training consultant and a frequent speaker on a range of topics in international arbitration and mediation throughout the world. He is a member of the African Arbitration Association on the panel of neutrals of the Lagos State Multi-Door Courthouse, Lagos Court of Arbitrations, and many, many other alternative dispute resolution institutions. We are very, very fortunate to have those members. And last but certainly not least is Gaston Kanfak, who is the Director of Legislation at the Ministry of Justice in Cameroon and holds a Doctorate of International Economic Law, Certificate on Trade, Negotiations and Settlement of Trade Disputes, and habilitation to direct researchers at the University of Pau in France. He is the President of the Association of the Promotion of Arbitration in Africa and will be very well known to all of you as one of the most active arbitrators on the continent. He's registered on the list of arbitrators of many institutions, including Exit, OHADA, and the PCA. He's a member of the board of directors of COSICA and the International Federation of Arbitration Centers and Associations. He is also the president of the 49th session of UNCITRAL. We are extremely fortunate to have this esteemed panel, and it's time to dive straight into the topics that we have to discuss. So the convention has come into force. The question, of course, the first question in any analysis of an international convention is the travaux préparatoire and the background to it. What was sought to be achieved? Now, Gaston, much has been said about this convention and the future, but of course, a historical analysis is critical. I understand that you are a delegate on behalf of Cameroon at the negotiation of the convention. Perhaps you can share some impressions and insights from that process, which will animate the motivation behind this convention.
Good morning, Vlad. Hi, everybody. Can you hear me?
Yes, we can, Gaston.
Thank you so much. Thank you. And Vlad, thank you for your good introduction. Yes, I confirm I was part of the Cameroonian delegation that took place to the negotiation, that took part to the negotiation of this Singapore Convention. And I must stress here that apart from this convention, the UNCITRAL was also of the opinion that in his flexibility manner to manage this instrument, apart from the convention, there should also be a model law for those states who are not ready to adopt the convention, because the convention is binding. You see, whereas the model law is very flexible. And if a state wants to make a legislation on mediation and is not yet to adopt the convention, it's up to this state to refer to the model law, to a model law. And in this regard, the UNCITRAL also updated the 2002 UNCITRAL model law on international mediation. You'll fairly understand why I have to stress this clarification now. Is to indicate that Cameroon is an OHADA contracting party. And while going to this UNCITRAL negotiation for the Singapore Convention, OHADA already had a uniform act on mediation, which purpose is to promote mediation as a tool of settlement dispute in commercial matter and in investment matter in the OHADA zone. And our purpose, our wish, while proposing that this Singapore Convention includes in its scope of application even amicable settlement reached on by the parties without the assistance of a mediator or of a conciliator, was because we wanted to reflect in this convention what we already have in the OHADA Uniform Act on Mediation. I've indicated that the purpose of this Uniform Act is to promote mediation. That is how to obtain exequatur for the agreement reached by the parties with the assistance of mediator or conciliator. But at the same time, we were of the, and we still are of the opinion that even agreement, amicable agreement concluded by the parties without the assistance of a mediator or of a conciliator should be taken into consideration here. So that was the proposal of the Cameroonian delegation. But what is interesting to stress here is that even some other delegations joined us in this proposal. And this delegation, it's important to indicate that they were not necessary from the OHADA space. Even non-OHADA space countries were of the same opinion. And because of the fact that the purpose of this Singapore Convention is first to promote mediation, it was not admitted that these provisions should be included within the convention, but there was a general agreement on the fact that it should be taken into consideration in the UNCITRAL model law, the 2018 version. That's why when you take this 2018 model law on international mediation, you will see that the section dealing with international settlement agreements states that in a footnote number 5, and I quote, a state may consider enacting this section to apply to agreements settling a dispute, irrespective of whether they resulted from mediation. You see, from an historical background, I think it's important to indicate this. And I think, Vlad, that is what I can say in order, you see, to answer to your question. But I remain available for more clarification. Thank you.
Yes, thank you very much. That's a very interesting insight, which of course doesn't appear from any of the documents that would have been publicly available to the participants. And it's important to understand that mediation is only one alternate dispute resolution mechanism, and one needs to think much more broadly if we're going to make alternate dispute resolution a viable mechanism for settlement of disputes. So that's very interesting. And what were the difficulties in negotiations? Were there some parties that that were resistant to some of the terms of the convention, that didn't or that led to the convention being qualified in any way?
Talking about difficulties, I can't really say that there was difficulties, because each delegation taking part to this negotiation was keen to come out with an instrument acceptable and agreeable to all. So the negotiations were conducted in a very courteous manner and in a spirit of mutual understanding. But I can mention, for example, Article 5 of the convention that states the conditions for refusal, the ground for refusal of the exequatur. You see, this provision is one of the length and more detailed provision of the convention. And this is why, not because any delegation had the intention to block the negotiation, but it's only because each delegation wished to reflect in the instrument, you see, its public policy in order to facilitate the implementation of the convention worldwide. That's what I can say to your question.
Yes, of course. That was a major point of negotiation in the New York Convention too. Yeah. And so the jurisprudence around both these conventions is probably going to weave together in due course. And it's interesting to see how different states' state interests are reflected in Article 5. And it's something that we'll probably develop further in our discussion.
Yeah, Vlad, you are right to mention the proximity of this Singapore Convention with the New York Convention, because if you can read it very carefully, you will see that it's nearly structured as the New York Convention. And I think this Singapore Convention is going to be for mediation what the New York Convention is for arbitration.
Yes, absolutely. And as you say, maybe it will branch out even into other forms of dispute resolution, but we take it one step at a time. In terms of its interaction with the New York Convention and litigation, I'd just like to pick that up right now. We might come back to it a bit further, but just to open it up to the panel as a whole, there is a carve-out in the convention that says any settlement agreements that are going to be made in order of court, or any settlement agreements that are made in arbitral award, are not going to be covered by the convention. Now, in terms of arbitral awards, I suppose they might be covered by New York Convention, but it seems that the carve-out in respect of the judgments and court orders is maybe quite limiting, because in many cases, parties want to make their mediation agreements orders of court so as to be enforceable within their own jurisdiction, but it seems to limit the enforceability overseas. What do panelists think about this particular limitation?
If I may just jump in there, Vlad, I think the concern, probably similar to the New York Convention, is that the Singapore Convention should not cut across existing legislation and treaties that exist on the recognition and enforcement of judgments. And I think it would create unnecessary confusion to traverse into that territory. I think the Singapore Convention was meant to be a new step in a new direction, which is to give enforceability to mediation, mediated settlement agreements in a way that didn't exist before, rather than change what was already there, and risk kind of delving into territory where I think the kind of consensus that would have been needed would be difficult to obtain, because effectively you'd be looking at some kind of very broad-ranging international convention on the enforcement of judgments that would kind of overhaul the existing system, and maybe that was a bit of an ambitious project.
Does anyone else want to?
Yeah, I would like to add that to avoid overlap with an international convention like the New York Convention, the Singapore Convention excludes from its scope of application agreements which are enforceable as judgment or arbitration awards. This is the precision I think it's important to make here.
Absolutely.
Can I comment at this point?
Yes, Agada?
Just to play the devil's advocate, it's clear, I mean, it's understandable when it comes to the issue of arbitral awards. However, do we really think that when it comes to settlement agreements which are entered as a judgment of the court, does it make sense to leave them out of the scope of implementation of the convention? Bearing in mind that the beauty of mediation is the fact that parties can opt to go to mediation at any time, and even in parties involved in an international dispute. So if the parties were prior to the opting to go to a mediation, found themselves before a court, and then, or as it's wont to happen on some occasion, maybe it's a commercial court, and the court is seized of the fact and understands that the nature of this dispute is one that parties could actually sit down at the table and have a conversation. And then those parties go and have that conversation. And at the end of that, they enter a settlement agreement, which the court then, of course, enters as a judgment. What would be the rationale for leaving that completely out of the scope of implementation of the convention? So I like
if I may, I think it's interesting because in that specific example you just gave, there would be effectively a judgment, and then it would be the judgment itself that was being enforced rather than the mediation agreement. Where I agree with you entirely is I think that the wording that's currently there, which includes mediation agreements in the course of proceedings that have been conducted, I think is the wording. That leaves it a bit open, because if parties start proceedings and then suspend and then enter into a mediation agreement separately, and they, for example, withdraw the court proceedings, I think each state will have to take a view on that, how that provision is applied. In my view, it would be excessive to exclude those agreements from the convention, but it's more where you have like a court ordered or a court supervised mediation where there's potentially more overlap with conventions on the enforcement of judgment.
Yes. So my point exactly. So there are instances where that mediation may not, parties may enter a settlement agreement, may elect not to have it as judgment of court, but because it's been part of a court process, or is a part of a court-directed mediation, leaving it out of the scope may become a problem. So I'm happy you see my way.
Yes, absolutely. And I think even further, I don't want to play more of a devil's advocate, but even mediation agreements that are made an order of court and therefore enforceable as a court judgment do create a problem, because there isn't the equivalent of the New York Convention, or at least not a workable equivalent internationally. There is the Hague Convention on the enforcement of civil judgments, but that has had very little success thus far, and it's going to be a long time before that becomes effective. So if you are stuck with with a mediation agreement that's been made in order of court, you might have to go through a double exequatur and all sorts of other processes and having it enforced in a foreign jurisdiction. So it's something to think about. It's certainly a limitation, and I think those entering into mediation agreement have to consider very carefully whether they want to make those mediation agreements orders of court, as it might have a greater impact internally within their jurisdiction if they do make it an order of court, but might hurt their chances internationally.
Since Dr. Carston was present during the negotiations, I wonder whether this was an issue. Was this an issue that was discussed, or was any attention paid to it?
Good question.
To my best knowledge, I don't remember that this was quite a problem. You see, the concern was to carefully determine the scope of application of the convention. Yeah. And in this regard, you see, judgment and arbitration award were excluded from the scope of application of this convention.
The fear, if Vlad, if I may just say, and Gaston, the fear is this: hope we do not find ourselves in a situation where we throw the baby away with the bathwater. I don't know if you get.
No, but as I've just mentioned, the OHADA Uniform Act on Mediation, there is a provision in this Uniform Act according to which when a state court is seized with an action by the parties, and if the state court deems accurate to send those parties to mediation, they may come out before this state court with an amicable settlement. And in that case, this amicable settlement will be recognized or enforced according to this Uniform Act on Mediation. You see, I think this partially at least solve Agada's problem. I think so. So I think your concern was you wonder why there is no such provision in the Singapore provision, but this Singapore provision is the general agreement where the international community could reach. But it's already something, because I think the mere existence of this convention is something very positive for the promotion of mediation as a tool for the settlement of commercial and even investment disputes.
True.
Absolutely. So I think a lot of food for thought. I should just mention to our audience, they're very welcome to send us questions. Those will be relayed to us and we'll answer them at the appropriate time. We've been talking around the motivations, background to the convention, some of the controversies in relation to its birth. But to get into the meat of it, we have to look at the provisions. I mean, ultimately, we are all lawyers or have some connection to law, and that's where a lot of debate generates from. And Justice Aluoch is going to take us through some of the core provisions at the heart of the convention, so that can spark further debate in this session. Judge?
Thank you very much, Vlad. And yes, I will take you through what I consider the provisions at the heart of the convention. Then I'll wait to hear from other panelists. The scope of the application, Article 1, which provides that the convention applies to international settlement agreements resulting from mediation, concluded in writing by parties to resolve commercial disputes. I think that is important. Article 1 also excludes from the scope of the convention, namely settlement agreements concluded by a consumer for personal, family, or household purposes, or relating to family inheritance or employment. Now, a settlement agreement that is enforceable as a judgment or as an arbitral award is also excluded from the scope of the convention. I think we have just been talking about that, to avoid possible overlap with the existing future conventions. I think we've talked about that. Maybe I won't say much on that. Now, Article 3 addresses the key obligations of the parties to the convention with respect to both enforcement to settlement agreements and the right of disputing party to invoke a settlement agreement covered by the convention. Each party to the convention may determine the procedural mechanisms that may be followed where the convention does not prescribe any requirement, maybe the inflexibility of mediation. Now, Article 4 covers the formalities for relying on a settlement agreement, namely, the disputing party shall supply to the competent authority the settlement agreement signed by them and evidence that the settlement agreement results from mediation. The competent authority may require any necessary document in order to verify that the requirements of the convention are complied with. The convention defines in Article 5 the grounds upon which a court may refuse to grant requests of the disputing party against whom it is invoked. These grounds can be grouped into three main categories, namely in relation to the disputing parties, the settlement agreement, and the mediation procedure. Now, Article 5 includes two additional grounds upon which the court may, on its own motion, refuse to grant relief. These grounds relate to public policy and the fact that the subject matter of the dispute cannot be settled by mediation. Now, with the aim to provide for the application of the most favorable framework for settlement agreements, Article 7 foresees the application of the more favorable law or treaty. Now, Article 8 includes reservations. A first reservation permits a party to the convention to exclude from the application settlement agreements to which it is a party or to which any governmental agencies or any person acting on behalf of the governmental agency is a party to the extent specified in the declaration. A second reservation permits a party to the convention to declare that it will apply the convention only to the extent that the disputing parties have agreed to its application. The convention and any reservations thereto apply prospectively to settlement agreements which have been concluded after the entry into force of the convention for the party concerned as provided in Article 9. The convention is consistent, as Dr. Gaston said, the convention is consistent with the ancestral model law on international commercial mediation and international settlement agreements resulting from mediation. This approach is intended to provide states with the flexibility to adopt either the convention, the model law, as a standalone text, or both the convention and the model law as complementary instruments of a comprehensive legal framework on mediation. Those are the sections the articles sections that I think are at the heart of the convention, but I'll wait to hear from my fellow panelists.
Yes, what do the panelists think are the key controversies in this convention? I mean, I can think of a few, but perhaps we should get the debate going with someone else raising a controversy. I can then add fuel to the fire.
Well, if you permit, the
yes.
opt-in opt-out provision, and maybe Gaston could throw some light on that, being one who was at the negotiation table. it has advantages, but then it could also create a situation where a state party could then use that as basis of escaping the terms of the settlement, which they have agreed willingly or otherwise with another party. I mean, that's what one sticky point that comes to mind immediately. And just to add, maybe if you don't mind, when we talk foreign policy, one danger with public policy, one danger that public policy issues then present is that public policy is never uniform. It is as it relates to different jurisdictions and different states. So I think these are some of the sticky issues that as a panel, it would be nice to throw some light on.
Absolutely. I think those are critical issues. If I can pick up on the public policy one, of course, it's been a major bone of contention in the context of the New York Convention, and the courts have had divergent views on whether it's domestic public policy or an internationalized public policy, and whether it applies, you apply the public policy of the state or of the regional community or the international community. So there's going to be a lot of ground to cover there for in court. But also it's not clear how you can apply public policy in a settlement agreement context, because one would have thought that it's a lesser, there has to be a lesser standard applied. This is an agreement between the parties. They've consciously entered into it. It's not an arbitral award rendered by an arbitrator in a neutral way and as an umpire to a dispute. This is what the parties have intended and wanted to enforce. So it will be very interesting. There are many nuances. I don't know whether panel members have thoughts about how the courts might approach this public policy paradigm. There is, of course, a very important judgment which is currently pending before the Judicial Committee of the Privy Council in the Betamax case on public policy, which we are everyone in the African arbitral community is watching closely, and that might give some guidance too.
Maybe the only comment I can make, is that, as far as I can remember, it's always been a ground for setting aside an arbitral award. But public policy is being used, sometimes it's actually misused. I'm a lawyer, so I can talk about lawyers. Sometimes it's misused by lawyers when the ground being relied on is that this was against public policy. So, but anyway.
Absolutely, and there are many nuances to that, because of course public policy doesn't define itself, and I think there'll be a lot of debate irrespective, because you've got lawyers on both sides of a dispute, but particularly so as this is in relation to agreements and not just in relation to an award. So it's very I think it's something to watch. But can I raise a further issue that just strikes me as a bit strange in this convention, or not strange, unsaid perhaps. I don't know what the effect of the recognition of the settlement agreement will be. Will it be made an order of court in the third party country? And if it is made an order of court, then is it going to lead to res judicata of the issues dealt with in the settlement agreement, in the mediation agreement? It's very strange, because of course domestically mediation agreements are not automatically orders of court. You still have to go to court to make them an order of court if you want to. So does this give a different hue to the mediation agreement once it's enforced in terms of this convention? I don't know whether anyone has thought on the panel has any thoughts on that issue.
Vlad, maybe I should draw your attention on the fact that I feel Selim has raised his hand. Maybe you didn't see it.
Oh, Salim, okay.
Yeah, I think If he's around, maybe he should put his question before we move forward, if you don't mind.
Okay.
Yes, of course. I didn't see the hand.
No, hello. No, it was a question that I have raised, and Amani has responded to it. But I think it's so. Good morning, everyone. First, perhaps it's important for the participants to hear about this question, and I'm convinced with Amani's answer. I was raising the issue of ARB Med ARB, so mediation, international settlement agreements resulting from an ARB Med ARB process. So in this case, we have an arbitration that has started, and then the arbitration has been suspended, and the parties have been referred to mediation through a mediator who is different from the arbitrators, and then they reach a settlement, and then their settlement is embodied in an arbitral award on agreed terms, an award by consent. So my question was, this settlement agreement, or this international settlement agreement, results from both mediation and arbitration. So what would be the applicable convention? My view was that the Singapore Convention would likely be excluded, and Amani's answer was that it is safer to enforce such settlement through the New York Convention. Perhaps another comment about the public policy defense. I believe that there is a room for the public policy defense, of course, when it comes to enforce a mediated settlement, or a settlement resulting from mediation, since it is not a matter of two parties reaching an amicable settlement, but the effect of the mediation on the state and the public order of the state in which the settlement will be enforced. I will give you an example. In Egypt, it is prohibited in certain geographic areas that lands be subject to the ownership of a foreigner, of a non-Egyptian. So imagine an amicable settlement, and the result of the amicable settlement is to permit a foreigner to become the owner of a land in this area. So this would contravene.
For public policy reason, the Egyptian code will necessarily reject this, will not recognize such an agreement, to my humble opinion.
Yes, exactly. Exactly. And this would pertain to not only Egyptian public policy, but international public policy of Egypt as well. So this example can apply to other countries. So thank you very much. I don't want to take much from your time. It was just a remark.
Right. Thank you. Vlad, if I can come in just on that comment by Dr. Salim. And thank you, Dr. Salim. Just to say that when parties sit down at mediation, especially in an international commercial dispute, it is unlikely, with the kind of advisors they would have and all that, that they would reach an agreement that would not take into cognizance the factors that relate to, for instance, the kind of example that Dr. Salim just gave. The concern for me as a person and as a practitioner is to avoid a situation where public policy becomes a factor that can be used to abuse the application of the convention. Because once we allow that, then getting the advantage that this gives to mediation will no longer be there anymore.
Absolutely. No, I think that's a very important point. And just sort of as a foil to what Ismail has mentioned, it seems to me that, of course, in certain circumstances where you are seeking specific performance, where there'll be specific performance of an unlawful act in the jurisdiction where it's sought to be enforced, that may very well be subject to public policy. But there could be other circumstances in what I would call the penumbra, where, for instance, punitive damages is something that's against public policy in many jurisdictions, if it's and will not be awarded locally. But when it's the subject of a foreign arbitral award, that sometimes the local courts also recoil at enforcing such an award. But if the parties agree that a party is entitled to, let's say, the compensatory damages are $5 million, but the party is entitled to $15 million in total. Well, yes, it's more than double the principal amount, but if the parties have agreed, there's no reason of public policy, or the public policy paradigm may be less important in the context of an agreement than it would be in the context of an arbitral award awarding the same amount. So there's a lot of, I think there's a lot of nuance in the application of public policy going forward. And of course, that's going to exercise a lot of legal minds. And who would want to stifle litigation? Right, okay. Moving on, thank you very much, Judge Aliot. That is a very, an excellent summary of the key provisions, and it's given rise to a lot of debate amongst the participants. And I'm sure we'll come back to these provisions in due course. But if I can move on, yes.
Can you allow me adding some few words concerning this public policy?
Absolutely, absolutely.
Okay, thank you. Just to indicate that even during the negotiation of this Singapore Convention, the mention of this public policy provision gave rise to many comments, you see, but I wish to indicate that states are not necessarily in bad faith with this provision of public policy, you see, and we should trust our judges in all our countries, in all the contracting parties. We must trust our judges because, you see, while before deciding that an agreement like that one will not be enforced because of public policy reasons. You see, it's not necessary because they are in bad faith. They can explain, and the decision is generally well reasoned to explain why, for public policy reasons, the agreement cannot be enforced, you see. So even during the negotiation, this discussion came out, but there was a general agreement that it's important to include this provision concerning public policy. It's just this clarification I wanted to add in some few words. Thank you.
Absolutely. So it's very important to trust the judges, but of course, this being an international convention, it gives rise to many cross-border and cultural issues, cultural adaptation issues. And it's very important, I think, to realize that whilst it's an international convention and there seems to be a growing consensus around mediation agreements, the success of the convention will, to a large extent, depend on how it can integrate within the cultures and legal systems throughout the world. Agada, will you perhaps take us through some of the cultural issues which could arise in the context of the convention, and what is your prognosis in terms of the take-up of this convention in its current form?
Well, thank you, Vlad. The convention, I mean, forgive me if I have played devil's advocate thus far, but the convention, certainly it's a welcome development and has major advantages for us as practitioners, mediators, and for parties, especially for those who are involved in international trade. But of course, as you rightly observed, and if you look at Africa, and Gaston's explanation, I think, captures it very well. We have within Africa, we have the OHADA, we have the Francophone, we have those of us who are in the West, English
speaking
common law, civil law dichotomy systems. So these, certainly these, all of these will have their impact on the way that generally as practitioners we respond to it. But I think the key thing to note is the differences notwithstanding, mediation has certain global principles that are of a global nature, which is that parties want to reach an agreement which belongs to them. Parties want to reach an agreement which defines their future relationship. So in that regard, I doubt if the differences in our approaches to legal practice will really be a problem. Because some of the things, the nuances that we find, maybe as it relates to like arbitration, for instance, a dispute resolution process, will not apply in mediation. The issues of document discovery and all those things, disclosure and all that, those are not issues that are going to be a problem here. The only thing that I suspect may be a challenge, it will be the ethical considerations as they play from different jurisdictions to other jurisdictions. And the kind of the understanding that different practitioners have of the role that the mediator may play. For instance, again, taken from the OHADA example as given by Gaston, there is that principle that an agreement, even though not reached with the intervention of a mediator, can still be considered as one which is a product of mediation. This would not sit well in some other, from an ethical point of view, some other practitioners in some of the other locations. So, and then of course, with court-connected ADR system, and we have a lot of that now coming up in Nigeria. I don't know how much of that is on the play in other jurisdictions. But here we have the multi-door courthouse system, which, and interestingly, if I may mention, it's very similar to the convention in the sense that rather than when you have a mediation agreement, you do not now need to go to court again to enforce, to get it recognized and then get another specific performance. Rather, you have the opportunity, because within the multi-door courthouse system, you have the ADR judge. Through a certain procedure, the ADR judge endorses the agreement of parties, and then it becomes judgment of court, which means that if a party were to default, you can take steps to enforce it under the Sheriff and Civil Processes Act without more. So from that point of view, because we have more court-connected ADR, mandatory mediation is now beginning to also rear its head under the Lagos High Court rules now. There is a provision, for instance, that parties, through certain procedural steps, are referred to mediation, and now are enjoined to attempt that process before they come. So because we'll all have different orientation, training, whether it's facilitative mediation or evaluative mediation, I think that probably would be the only challenge that I see with the convention in terms of its application generally. Those are my two thoughts.
Thank you very much, Garda. That is certainly food for thought on the cultural issues. Now, if we can drill down before we discuss these kinds of cross-border matters, if we can drill down into the legal codes and how you think, Amani, it will be received within the legal codes, how it will be practically integrated. What do you think are some of the issues that we need to look out for?
I think there's an elephant in the room, and that elephant is the relatively slow ratification by states of the convention. I personally don't have an explanation for that. I imagine there's some reluctance at different levels in different jurisdictions about the convention itself. And I think the first step would be to flush out and identify those concerns. Is there a concern, for example, that this could be used, for example, to launder money? What is it exactly, or what are the fears? And I think the first and very important step to take would be to get those out in the open and to discuss them openly within, at a political level. That's sort of not happening at the level of lawyers, but at the level perhaps of government and the judiciary, and understanding really how the convention could impact trade in a specific country, and just being able to get the buy-in politically for people to see the benefits that could result from this, and the inefficiencies that exist in the present system, where you have to effectively sue on a fully negotiated and agreed settlement, and the money that's wasted in that way, and just to have a really honest conversation around it. I think the second thing that's really a very clear obstacle to, you know, the more widespread practical impact of the convention is the incentive to mediate in the first place. Now, different jurisdictions have, over the course of the last decades, updated their civil procedure codes so that parties are very strongly incentivized to settle meritorious claims. So the majority of my practice has been in Egypt, where unfortunately the Code of Civil Procedure remains somewhat out of date. In cases where you have a clear claimant party and a clear respondent party, that is somebody who stands to lose from the enforcement of a right and somebody else who stands to gain with divergent interests, it is very, very difficult to explain the reasons or the incentives why that party should engage in mediation in the first place. And I think the uptake in the convention is an important part of enforcing sort of mediation at the back end, so to speak, but we shouldn't lose sight of what happens at the front end. And I think just in terms of volume, and maybe my perspective is a bit skewed because in addition to being an accredited mediator, I'm an arbitrator. I do much more of one than the other. Just to really think about how it is that we can avoid some of the major inefficiencies that exist in the present system when it comes to enforcing rights more broadly, making sure that commercial parties are properly incentivized. I think, you know, many of my clients don't prefer arbitration because they recognize the huge time and cost implications of enforcing claims that way. But in a situation where they have no other choice, there still aren't the incentives for the other side to come to the table that there are perhaps in other jurisdictions where you can be penalized on costs. So for example, Part 36 offers in England and Wales that penalize parties financially for rejecting offers of settlement that are sort of meritorious or fair, and end up being classified as such by reference to the judgment in the proceedings. So I think all of that is missing in Egypt. It's very, very easy to postpone and drag out litigation unnecessarily, and even after it's finished, it's very easy to, or just put it conversely, it's very hard to actually turn your judgment into money. And those are things that I think at the moment are incentivizing respondent parties to sit on their hands and transfer the burden of enforcement to the claimant party. And I think that the sector of the economy that hurts the most is small and medium-sized businesses that can't afford to engage in expensive arbitration proceedings. So I think all of that is stuff that we need to think about if we're going to, if the Singapore Convention is going to fulfill its potential, if mediation is going to fulfill its potential globally.
Yes, so I think everyone on the panel has agreed that it's a very important step forward, and in fact can promote dispute resolution and can give access to justice. But one needs to assess why it is that there's been a slow take-up in respect of the mediation. And Mani has mentioned that possibly it's that there isn't a neutral arbitrator or neutral party actually pronouncing on the right. So it can give rise to illicit or irregular agreements being given effect, and that's something to think about. Of course, the problem arises is when it comes to enforcement, the only two parties to those proceedings are likely to be the parties signing the agreement, who would not want to reveal the underlying cause. So that's definitely something to consider. What do others think on the panel?
Well, if I may just, I agree with Amani that part of the challenge is as it relates to maybe the preference, for instance, for the certainty that comes from arbitration as against, and I think that is the major problem that mediation in most jurisdictions has had. The fact that people still do not understand clearly why, how the process is non-binding, only the outcome is binding, and even that outcome, what becomes of it, as against an arbitral proceeding which is binding all the way. But from a commercial point of view, and I think this is what maybe as practitioners we need to begin to sell very quickly, there is need to begin to educate people in our different jurisdictions about the efficacy of mediation. There may be a need to interact with the business community to explain to them how the process of mediation in a sense works and the advantages that it brings to them in the expeditious way, time-effective way that you can have matters resolved. And once that front end is dealt with, the back end issue of how to enforce it can be supported by the convention, and of course, some amendments in the civil procedural rules of the relevant states. Those would be my views.
I would also like to add that a deliberate effort should also be made to make lawyers understand what mediation is, because almost most parties are represented by lawyers. And if they understand how mediation works and the benefits of mediation, they'll be able to help their clients a lot. Because most parties will say that my lawyer told me, let's go and try this thing. And by this thing, they are talking about mediation. So as much as we educate the public, we also need to have sessions with lawyers. And I'm happy to note that there are many lawyers who nowadays come for mediation training, which I think is a good thing.
Yes.
Then in that way, it's easier for them also to explain to their clients that, you know, it works this way and it takes a shorter time and this and this. But then, you know, the way it's said that a mediation could be settled in one day, and then, as some lawyers tell me, then you lose that you are finished with that client. You don't see the client again because the matter was settled. So that is also at the back of, you know, at the back of the minds of lawyers also. Yeah. But I think it's a community that we need to explain the mediation process to as much as possible. Yeah.
Absolutely. Education is critical, and also on the chat, I think this has been, this is supported. Education is critical, and in my experience, certainly with clients, they yearn for a negotiated or mediated settlement. But mediation works best when everyone, of course, is informed about it and about its benefits, and also there's a trained mediator who's facilitating it. It's very important to have someone who can hold the party's hand and who can steer the process properly. So I think this is something that requires a cultural shift by lawyers and the legal profession. And actually, contrary to their fears, you'll see that the clients will keep on coming back to them because they see the process, guiding them in the most efficient way towards the resolution of a dispute. No client wants to be stuck in a dispute for any longer than they absolutely have to. It is very much a grudge purchase. What do others think?
Vlad, may I say something?
Of course.
Yeah.
Okay, thank you, Vlad. Let me very humbly insist on the necessity for the lawyers to be educated, because yes, education is very important, but for the parties to be educated, the lawyer should first be educated, be aware of the interest, of the flexibility, of the advantages arbitration includes before explaining it to the parties. So I wanted to insist of our role as lawyer to educate the party. If we want to be efficient, we must first be educated on what arbitration or mediation is about, exactly on as we do with arbitration, because a party will easily be convinced if his lawyer is able to explain very easily to him what mediation is about, its advantages, its interest. So this is what I wanted to add.
Absolutely.
And
It is.
if I may just chip
Yes.
in very quickly.
Got it.
One major thing that we need to, while educating the lawyers and lead other people, one major distinction we must let them understand, one major issue they must understand, and the distinction we must draw is when disputes arise, especially in the commercial context, we need to be able to educate the clients and the lawyers that this is a business problem as against a dispute in the ordinary sense of it. So it's not about two people just having a quarrel. They have the quarrel or the disagreement as it relates to something that is distributed between them. And it's more sensible to sit down and have a conversation, especially where interest, there are commercial concerns, interest is running, maybe there are loans, there's a construction of some sort and all that, or it's something, it's a contract that where the relationship, for instance, particularly in the oil and gas sector, where the relationship usually spans several years or decades, it is essential that parties who want to be able to continue to work together see whatever problem that arises between them as a business problem that needs to be addressed, rather than just a judge dispute where they need to prove each other wrong about one another.
Absolutely. It's a question of a paradigm shift from rights to interests, to understand that the purposes of mediation are different, and that the parties seek to achieve a business interests outcome, and that's very, very important. And I think the irony, of course, of mediation is that it's channeled through people who are largely trained in issues of rights and who have for decades practiced issue of rights rather than interests. And some of them have no interest in interests. Some of them have no interest in the business or commerce or the like. So it requires a lot of training and a lot of just rethinking of this, and perhaps it should start with universities also integrating a proper mediation modules where mediation is seen as a key component of the legal education. Maybe that's the way we start turning it around. But this convention, I think, once it becomes a more widely held legal instrument, might lead to those kinds of reforms and differences in thinking. So if more states take it up, it might become more and more popular amongst the legal profession. What do people think about? Yes, Judge.
I was just going to say that the paradigm shift you are talking about is as much as judges who are used to making orders throughout our judicial careers suddenly becoming mediators and thereby facilitating discussions between parties so that they can arrive at a settlement, they can live with. So even there, the paradigm shift continues. Yeah.
Absolutely. It has to be throughout the legal profession and anyone associated with it. What do people think is the future of this convention? What do we, because there are obviously quite a few nuances, and we know there'll be battles around that. There are many provisions, and if we have any time, perhaps we can discuss provisions like the requirement that the obligations in the settlement agreement are clear and comprehensible, whatever comprehensible means. There's the issue of public policy. There are many other issues. But what do people think at a broad level is the future of this convention? What do you think? What do you anticipate peering into your crystal ball?
Can I come in and say something about? I've just I've been wondering why the UK and the European Union countries are not signing or at least signing to begin with before ratification. And then I came across something that I thought was so interesting, and maybe I can share what I came across. Can I?
You must.
That it is important to underline that the convention does not take any stand on the source of mediation. For example, the parties may have resorted voluntarily to mediation or resorted to mediate instead of commencing litigation. They might have just decided the usual thing, voluntary. Or an attempt at mediation may have been mandatory by a legal rule or by a court. This is an issue that I found is debated a lot in the European Union, where some member states believe that the only way to resort to mediation is to make the mediation mandatory. I was a bit surprised when I saw this. And this does not surface anywhere in the convention. Would it be the reason why the UK and the European Union countries have not signed the convention? Maybe any one of you can, the panelists, you can think through it like I'm thinking through it.
Well, Gaston?
Yeah, just some few words.
Yes.
The impression, I think now, is that there are states are reluctant. I think it has been indicated. But you see, before becoming what it is now, the New York Convention was exactly the same. You see, the state negotiates a convention. Now they have the convention. They might take time, you see, to sign and to become party to this convention. But I can only say that the progress, it might be long, but it is in the process, it is in progress. And I think through education, as we have just mentioned, even those states that might be reluctant will understand the advantages and the utility of mediation. And I think we should not be tired for promoting mediation through education. And Vlad had said something which to me is very important. From the university, you see, we might have a section on mediation. And it's this way, I think, little by little, we will reach a situation whereby mediation appears to be something very useful for the commercial or investment community. I think we should be very patient and very pedagogic also. But education, even at the interest of the state, is something very important. That's what I can say at this stage of our exchanges.
Yes, and of course, only 5 countries originally ratified the New York Convention. and now we have 168. It's taken a few decades, but we got there. I think Agada had some comments.
Yeah, just to add and to build on what Gaston said, I see, looking in the crystal ball, that the convention has come to stay. Yes, there are nuances and that there will be challenges in the implementation going forward. But just as you have observed, like the New York Convention, it will take its time. But one major, I think we can, looking at the crystal ball, one major advantage or one factor that is going to help the convention very well is the fact that if you look at there is now greater awareness and some sort of shift, paradigm shift, if I may use that word, towards investor-state mediation. And so if you look at, so many bilateral investment treaties either now are expressly making provision for resort to mediation, or the fact that, and then even ICSID, there's now the ICSID is developing rules on mediation, resolution of the investor-state disputes using mediation. So with such developments, particularly as it relates to investor-state mediation, and the fact that, as most of us who are practitioners know, most states have never fared very well out of investment-state disputes relating to arbitration. I mean, it's the states usually, and then many bilateral investment treaties, when you analyze them, do not seem to be very favorable to states. The fact that mediation then presents an opportunity for parties to have a conversation about the issues rather than have a third party determine, and sometimes, especially even from a public policy point of view, from an economic point of view, sitting down at mediation to discuss the issues may provide a more realistic benefit to the states than in arbitration. So I see the convention gaining more traction over the next few years, particularly from that perspective.
Yes, it has. I think it has a huge potential in investor-state disputes, because there are other dimensions to those kinds of disputes where there might be broader implications of an arbitral award adverse to the state or to the investor. And the publicity, reputational issues, broader regulatory issues might make those parties more susceptible to coming to resolution. I completely agree. I think that's a key, could be a key development. And of course, if it's taken up at that level, it will gain international acclaim immediately, and state parties would be more willing to accede to the convention, and maybe even the EU parties. I think there are complexities in respect of the EU, since the ECJ judgment, which effectively rendered all the intra-EU bilateral investment treaties null and void. I think has put a different spin on international conventions and any kind of harmonization of that sort. So there are broader implications. Could I just ask the panelists? There's a question that's been raised in the chat. Could I ask the panelists to respond to this? And it's the issue of whether mediation is being treated as a special kind of settlement, and why that is not being extended broader into other forms of settlement. Now, I know Gaston has touched on it earlier in his address, but perhaps we can develop that a little bit more, and whether you think there is a principled distinction to be drawn between mediation and other forms of settlement agreements.
And if I may just jump in there, I think the answer is there is. And it all depends on how sort of pro-enforcement or how pro-party autonomy you want to be, and what you see as the ideological limits on that are. Effectively, what's being suggested here is that you would be enforcing an agreement, which is just a type of contract, directly without any kind of sort of supervisory supervision by the courts or by an arbitrator, and no involvement of any third parties whatsoever. So in addition to the money laundering sort of risk that I sort of mentioned earlier, potentially there's also the situation where a party wants to argue that the agreement was entered into by duress, or there are other kind of legal rules that would vitiate consent or call into question the validity of the agreement more broadly. So I think if you have a spectrum everywhere, sort of at the very one end, you've got just an ordinary commercial contract. And then at the other end, you have a binding court judgment. And in the middle, you have an arbitral award, and somewhere else, you know, further down the scale, you have a mediated settlement agreement. I think there is a principal distinction that you can draw in terms of mitigating the risks of abuse by having involvement of a third party. So I think what's being suggested here would go sort of further towards just the simple direct enforcement of contracts. And I think people are understandably a little bit more risk averse when it comes to that kind of enforcement than they would be in a more formal mediation setting. And I think it would be maybe just one step too far to get the kind of buy-in from states that you would need to ensure the uptake. So I think there's always compromises that need to be made when you're trying to get a very multilateral approach and a lot of buy-in from a lot of different countries, and which you need to make it practically effective. So I think perhaps a better case could be made for enforcing mediated settlement agreements than just other agreements. And then you've got all kinds of threshold questions. I mean, where do you draw the line between a settlement agreement and an ordinary contract as well?
Yes, thank you very much.
Can I say something
Yes.
clear?
Yes, Judge.
Yeah. One thing that is we should always bear in mind is that mediation is the oldest form of dispute resolution, a mechanism. I mean, it's been practiced for many, many years. It's just that nowadays it's formalized, isn't it? Communities do mediate, and they have been mediating over the years. So when somebody asks whether mediation is being treated as a special, no, it has always been there, but it's just that now it's there in a different form, it's formalized. But the mediation that goes on in most African countries is not formalized. I mean, in the villages, mediation go on with elders. And that is one thing that we must never forget as we talk about mediation, really.
Yeah, absolutely. These are critical considerations. And I think there is a distinction to be drawn from a historical perspective and potentially a principal perspective, as outlined by Judge Alioch and Amani. So it's these are all important issues which I think will play themselves out. In addition, of course, to the issue which is might be the second elephant in the room, and that's the question of whether there can be an abuse of the process as a whole, and whether that's going to be a further basis on which people will attack mediated agreements, as Amani has raised earlier in the discussion. So I think there's lots of fertile ground for debate, discussion, and writing on this topic. And I would encourage everyone who's participated in this panel, both as a panel member and as part of the audience, to think about these issues and perhaps write something in legal journals and spread the word in relation to the convention and mediation more generally. And perhaps we can all take back to our respective places of practice the lessons about the importance of education. And maybe if we have involvement in universities, we can initiate reform at that level too. I'd like to thank all the members of the panel very much for their stellar contributions. It really has been excellent. It's one of the very best panels I've been on. And it's, I think it's given a lot of people food for thought, in addition to being very informative. And I hope everyone now goes out and conquers the mediation beast. Thank you all.
Thank you very much, Vlad, and thank you, everybody.
Thank you.
Have a wonderful day.
Thank you very much for
Thanks.
the invitation. Thank you very much, Vlad.
Thank you.
Thank
Thank
you.
you.
Thank
Bye-bye.
you. Bye.
Thank you. Bye.
Bye-bye. Bye-bye. Yeah. We can leave now.
Yeah.